Hello and welcome to Runkle to the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So my birthday's coming up soon, and the universe has delivered one hell of a gift. Aw, you shouldn't have. Alright, this is the case of Canada and Smycott, which has also been listed as Canada and Stark. This is a really big deal. This is an application by Canada, by the Attorney General, for something called certiorari of an original decision, the decision of Judge Fradsham, which rejected their argument about jurisdiction. Now, this is basically an appeal. When I say certiorari, this is a place where we've got Latin and so forth. It's a form of appeal. So Canada wanted to challenge this decision because it didn't go their way. So I'm going to have a look. We're going to go through this, but this is a really big deal. And quite frankly, I'm quite pleased with this decision, although I don't think that they got everything right. So I'm going to note where I think they got things wrong as well. Let's have a look here. As noted, there's lots of people involved in this one. I'm going to cover things as we need to, but I'm also going to cut stuff out. So I'll link a copy of the original decision below so you can check it out yourself. So reasons for decision on certiorari applications of the Honorable Mr. Justice G.H. Pullman. Introduction. The respondents are all firearms owners who sought relief in the Provincial Court of Alberta from consequences of their firearms being reclassified by federal regulations. And I don't necessarily agree with that statement, but this is just the introduction. This is just kind of byline blurb. So the Attorney General for Canada argued that the provincial court did not have jurisdiction to hear the statutory reference under which the respondents applied. The learned provincial court judge, Fradsham PCJ, decided, with written reasons, that he had jurisdiction to hear the statutory references, and there's a citation. Canada applied in Queen's Bench to quash that decision. Despite the objections of the respondents, on June 1st, 2021, I decided that Canada's application for certiorari should be heard before the reference hearings proceeded in provincial court. The certiorari applications were argued on 2 dates, and this is the decision resulting therefrom. So this is basically just talking a little bit about procedure stuff. So Judge Fradsham said, I've got jurisdiction to hear this. I'm going to hear this decision. And then they applied for certiorari, which again is kind of an appeal. They wanted to quash that decision, that he had jurisdiction. And so the respondents, Smycott, Stark, etc., wanted to have the matter heard right away. They wanted to get to the decision, or the decision on the merits first, but the court said, no, before we can have the hearing on the merits, we have to decide this certiorari issue. So we're going to hear that first. All right, so that's what's going on so far. They say the only question before me is whether the provincial court has jurisdiction under Section 74, Sub 1 of the Firearms Act, as amended, to hear firearms references in relation to letters sent by the Registrar of Firearms, the registrar, that the respondents say constituted revocations of their registration certificates. So that's what this issue is that can these Section 74 hearings happen at all? So legislative framework, basically they say it's the Firearms Act and the Criminal Code. I'm going to skip over parts of this, but read some other parts. So just as I said, it's linked in the description below if you want the full case. So the purpose of the Firearms Act is set out in Section 4. It is to provide for the issuance of licenses, authorizations, and registration certificates under which firearms may be possessed in circumstances that would otherwise constitute a criminal offense. Because in fact, if you look at it, guns are banned in Canada, but there is an exception, which is the exception is if you've got a license, then you can possess them. So Section 14 provides that registration certificates may only be issued with a firearm for a firearm with a unique serial number, and that is described in the prescribed manner. And the registration certificates in the record on these applications demonstrate that each are issued for a specific firearm, so that one person may hold a number of registration certificates. They state that the registration certificate is valid until the firearm is transferred or disposed of, or the certificate is revoked. In other words, they are not limited by a term or expiry date. So that's kind of a critical thing here. Carrying on, I'm going to skip over parts of it again, but when revoking a registration certificate, the registrar must provide a notice of revocation in the prescribed form. So this is a responsibility on the registrar. And one of the interesting things about this case is that they've tried to turn this responsibility into a power. And what I mean by that is that they say, listen, if we don't provide you this notice in the prescribed form, then that means it's not a decision. This is an argument that they have made repeatedly. And I think that the courts need to really hammer down in rejecting this, because This is the kind of argument that is a terrible thing to allow or to, consider as an option for any administrative decision maker. Nobody should be able to rely on their failure to comply with statutory obligations as to achieve some sort of benefit. That, to my mind, is really not how the law ought to work. So, carrying on. The notice must include the reasons for the decision, disclosing the nature of the information relied on for the decision, and must be accompanied by a copy of sections 74 to 81, which outline the reference hearing and the appeal processes. Sections 2, 72 sub 1, and 72 sub 2. So those are the citations for what makes that happen. Now, note here, they have to provide not just why they made the decision, but also information on how to challenge them. That's because this is a government. They're supposed to be held to a higher standard. And they're supposed to be, sort of upstanding and say, listen, this is our decision, but here's how you challenge it. Here's how you go about getting your legal remedies. These are provisions that are very much intended to help the little guy. And that's, again, what they're sort of trying to escape from here. So further, the notice in respect of a registration certificate for a prohibited firearm or a restricted firearm must specify the manner of delivery or other lawful disposition of the firearm within a reasonable time, during which time the criminal code provisions regarding unlawful possession do not apply. Section 72 sub 5. So that's a provision that basically says, listen, just because they revoked your registration certificate doesn't mean you immediately have to surrender it for disposal, because you actually have this period, a grace period, to allow you to challenge it. And if you challenge it, it actually suspends that expiry, or the expiry of that period. So it actually says, listen, you can keep the firearms while that challenge is ongoing. So the provincial court has jurisdiction to hear references of certain decisions made by the registrar pursuant to sections 74 to 76 of the Firearms Act. Section 74 sub 1 sub A allows a referral where the registrar refuses to issue or revokes a registration certificate. Section 75 sets out the procedure for the court to conduct the hearing. Under Section 76, the provincial court judge may, by order, confirm the decision, direct issuance of a registration certificate, or cancel the revocation. An appeal is permitted under Section 77 from an order under 76. So there's this whole process of this is how appeals work under the Firearms Act, etc. So I'm going to skip over all of the criminal code stuff. I'm going to skip over the amendments to regulations. So procedural history. This is what happened in the case thus far. So the firearms owners took the position that the registrar's letters were revocations of their registration certificates within the meaning of Section 72 sub 1 of the Firearms Act, and referred the matter, to use the statutory language, to the Provincial Court of Alberta under Section 74 sub 1. So that's what's happening here. They say, and they're right about this. I mean, they are revocations. That's my take anyway. So Canada applied to strike these applications for reference hearings on the ground that the letters did not constitute revocation decisions, and therefore the provincial court had no jurisdiction to conduct or consider the proposed references. Fradsham PCJ heard the applications to strike and decided that the registrar's letters were revocations within the meaning of the Firearms Act, and he had jurisdiction to hear the Section 74 sub 1 referral of the decision. He gave 9 decisions, one for each of the respondents, to the same effect. So that's just a sort of how he chose to write and issue those decisions. That doesn't much matter here, just in case anyone's wondering. So Canada applied to Queen's Bench pursuant to Rule 3.15 of the Alberta Rules of Court for orders in the nature of certiorari quashing Fradsham's PCJ decisions on the ground that he erred in determining that the provincial court has jurisdiction under the Firearms Act to hear firearms references of the registrar's letters. Canada's position, so this is what the government says, is that the letters were not decisions or exercises of the judgment that affected nullification or revocation. Rather, the registrar merely reported on the legal effect of the order in council. Of course, they've never actually been able to point to what would trigger this supposed legal effect. There is no actual provision that creates an automatic nullification. Nullification appears nowhere in the Firearms Act or the Criminal Code sections about firearms. It might appear somewhere else in the Criminal Code. Criminal Code is super long. So thus, there was no basis for a reference to the provincial court. As noted, I disagree entirely, but I'm currently fighting them on this same decision with a little less luck than they're having over here with Fradsham. So, as noted earlier, I dismissed the respondent's application to strike Canada's certiorari application for prematurity. Thus, the hearing on the merits of the certiorari application proceeded. So yeah, that was just that they wanted to hear the full case before the certiorari application was heard. So the reason why they might do that is, amongst other things, if they lose on the merits, then there's not a whole lot of point. The certiorari application would become moot, and that saves all of these people a lot of time and money. But if they win, then they can hear everything all together, which again saves everyone some time and money. And I'll note here, in terms of the balance of time and money, the government basically has unlimited resources to spend on this. They're going to be spending taxpayer dollars, and as far as the government's concerned, that's an inexhaustible resource. If you need more money from the taxpayers, well, just go back and take some more. So the respondents are paying, they're on their own dime here. So anything that makes things more expensive benefits the government in a fight between the government and the people. That is always the case. There is an inequality that applies there. As I said in my earlier decision, certiorari is a common law remedy used to bring decisions of statutory delegates and tribunals, including provincial courts, before a superior court where the decisions can be quashed if the delegate or tribunal acted without jurisdiction. So that's just a nice explanation of what certiorari is. But again, the real quick and dirty explanation is it's a form of appeal. So Canada submits that the only question is whether Fradsham erred in finding that the registrar's letters constituted revocation decisions, a characterization that would be required for the provincial court to have jurisdiction to hear the respondents' applications for references under Section 74 of the Firearms Act. Among themselves, respondents take different positions on how to frame the issue, because there's lots of people and they all have a different take. Having read and heard their submissions, however, I do not see a significant difference between most of them and Canada. I agree with how Canada frames the decision. It is wrong to start with a question, as proposed by the respondents Stark and Dolan, asking whether regulations under Section 117.15 of the Criminal Code result in the invalidation or nullification of a registration certificate. On certiorari, the question is always focused on reviewing the decision of the statutory tribunal, here the provincial court, under the proper standard of review. And I'm going to go over the standard of review section because although it is probably going to seem super boring to many of you, standard of review is critical and many cases are won and lost on the standard of review. So let's have a look at this. So on to standard of review. Judicial review of a statutory tribunal's decision presumptively is based on the standard of reasonableness, and that's from a case called Vavilov, which is an administrative law decision talking about how you appeal the decisions of administrative bodies. In a marked departure from earlier jurisprudence, the reasonableness standard also applies to questions concerning the tribunal's jurisdiction. Now, it's kind of worth noting here that firearm law is this weird and unholy hybrid between criminal law and administrative law and stuff that is unique to firearms law, all kind of welded together by the sort of welder who doesn't wear eye protection and also is, keeps a bottle of liquor within reach as they weld. So it's this really unusual area of law, which is part of what makes it fun. So departure from the reasonableness standard of review applies only where respect for the rule of law requires a singular, determinate, and final answer to the question before it. And that's from paragraphs 32 and 53 of Vavilov. That will be the case for constitutional questions, general questions of law of central importance to the legal system as a whole, and questions regarding the jurisdictional boundaries between two or more administrative bodies. Constitutional questions involve such matters as division of powers, relationship between the legislature and other branches of the state, and other constitutional matters that require a final and determinative answer from the court. Questions of law of central importance are those which have an impact on the administration of justice as a whole or other institutions of government. The mere fact that a dispute is of wider public concern or touches on an important issue does not necessarily bring it within the category of a general question of law of central importance to the legal system as a whole to which the standard of correctness would apply. So let's talk about reasonableness versus correctness. Basically, correctness means is that the lower court or the administrative decision maker has to have gotten the answer right exactly. And so if a higher court says, listen, this is not correct, this is not right, they will change that decision and implement one that is correct. Reasonableness allows for this range of decisions where you say this decision was a mistake, or we don't like this decision, we think this decision was wrong. But because it's a decision that you could reasonably reach, even though we disagree with it, we're not gonna move it. And you might be saying, wait a minute, why do we have this whole legal standard of you can be wrong, but there is no remedy? And that is a political and philosophical question, but the sort of the practical reason is that you want some certainty to decisions. You don't want it that every decision is something that can easily be changed. So they're trying to limit this to decisions that are sort of really wrong, that are decisions that are unreasonable or made based on some sort of error in principle in some fashion. So that's kind of the reason for this. Now, when you look at these kinds of decisions, if you like the underlying decision, usually you want to argue for a reasonableness standard to say, listen, that's the standard that should apply is reasonableness. And if you don't like the underlying decision, usually you want to say correctness. I only need to show a little mistake and then I can flip it. Now, that's going to get interesting as we look further. So I'll talk about that a little bit. So Canada, the party seeking to quash the provincial court decision, acknowledges that the reasonableness standard applies. Some respondents agree, while Stark and Dolan submit that the standard is correctness. Personally, I agree that the standard here should be correctness, because in my view, this is a massive issue that does in fact touch on the administration of justice as a whole. It touches on criminal law issues. It touches on sort of a division of powers type kind of question in terms of criminal law versus this. I think that this is a proper place for correctness. And I will say, I think that this is a place where this decision got this one wrong. But Canada acknowledge reasonableness applies, notwithstanding the fact that they're actually trying to flip the decision. Normally, a person in that position would be arguing for correctness. Now, there's a couple of reasons why they might do that. First, counsel there may and probably are just acting out of straight up ethics and saying, listen, we think this is the correct interpretation of the law, notwithstanding that it hurts us. That's what we're stuck with. And that is a stand-up ethical position to take. Absolutely. The other thing, however, that might be a consideration, and I can't say it is because, quite frankly, I think ethics is enough to get us there. But they may also be looking at the fact that I'm going to be bringing my own application, and reasonableness will help them when I come after them in the that certiorari decision. So I can't say what the consideration is, but it's probably just that this is what they actually think it properly is. I personally think that this is an area for correctness, but yeah. So keeping going. Their argument is based on there being many similar proceedings in Alberta, and this is Stark and Dolan, and throughout Canada, and my decision will bind the lower courts in these cases throughout Alberta. In my view, that takes too broad of a view of what Vavilov means by questions of central importance to the legal system. As noted above, it is not sufficient that there be a matter of wide public concern or something that, when framed generally, touches on an important issue. To fall within the category of a correctness standard, the questions must be of fundamental importance and broad applicability with significant consequences for the justice or governmental system as a whole. And I think, quite frankly, this is one of those issues, because the tactic that was taken in this case, if applied to, for instance, immigration decisions, would be immense. This is, I think, a really big and really important decision. So I conclude that the reasonableness standard applies to the question before me, namely whether the impugned decision involves an error in finding that the registrar's letters constituted revocation decisions. Where the reasonableness standard of review applies, the party challenging the decision bears the burden of showing unreasonableness. So that's Vavilov. So again, if you want to change the decision, you have the evidentiary and argumentative burden. You're the one who has to overcome something. So that again makes it harder on that challenger. So for the decision to be quashed on the basis of unreasonableness, the court must be satisfied that there are sufficiently serious shortcomings in the decision such that it cannot be said to exhibit the requisite degree of justification, intelligibility, and transparency. In some cases, there may not be much practical difference between the standards of reasonableness and correctness. The more deferential standard of review does not give license for tribunals to enlarge their powers beyond what the legislature intended. Conversely, I would say that the same thing applies, that the more deferential standard of review should not give license for tribunals, and this is me talking here, the second sentence, to diminish their powers beyond what the legislature intended, because, the legislature, when they set up a statutory review process, intends for that to be useful and used. So careful regard must be paid to the statutory language because precise or narrow language may limit the number of reasonable interpretations, even to only one, or allow the decision maker greater leeway in interpreting its enabling statute. And that's again from Vavilov. The statutory language given the provincial court jurisdiction in a firearms reference is of limited assistance in determining whether greater or less leeway should be given for it to interpret its enabling statute. The language confers jurisdiction where the registrar revokes a registration certificate. If the registrar so revokes, the holder of the registration certificate may refer the matter to a provincial court judge. Nothing in those words is of particular assistance in determining how deferential the reasonableness standard should be. All right, so ultimately they take the standard of reasonableness, but this kind of is touching on a problem with the whole reasonableness aspect. And if I were teaching an administrative law class, which I'm not going to be doing because I am not the guy for that, and over at the U of A, they've got an excellent guy teaching that, this, I think, would be sort of a good illustration of how reasonableness isn't all that helpful as a standard necessarily, because what does reasonableness mean in a particular circumstance? Well, anyway, let's keep going and talk about the issue of nullified, no longer valid, and revoked. Fradsham studied the registrar's letters, the statutes, applicable cases, and dictionary definitions before arriving at his conclusion that the act of the registrar which nullified and made no longer valid the registration certificates was the revocation of those registration certificates, paragraph 70. The same issues arise before me in determining whether the impugned decision was reasonable. If those words used by the registrar in his letters, nullified and no longer valid, mean the same as revoked, there is a reasonable basis for concluding that the letters come squarely within the language of Section 74, sub 1, sub A of the Firearms Act. That's the section that allows the provincial court to review those decisions. I leave aside for the moment the issue of whether the revocation, if that is what those words mean, was affected by the registrar or by operation of law. Fradsham notes that the terms nullified and no longer valid do not appear in the Firearms Act or Criminal Code, but that the only states of being for registration certificates are issuance, expiry, surrender, and revocation, which is correct. There isn't any, this nullified and no longer valid, and later they invented the term of administratively expired. None of those things actually exist. So in determining whether it is reasonable to equate revocation with nullification or invalidity, it is useful to consider the purpose of a firearms registration certificate. Section 4 sub A of the Firearms Act indicates that the purpose of a registration certificate is to authorize a person to possess a firearm, the possession of which would otherwise constitute an offense under the criminal code. So the registrar's letter says that the respondent's registration certificates are automatically nullified and therefore no longer valid, and that the certificate numbers are listed under the caption, no longer valid. The Canadian Oxford Dictionary defines invalid as not officially acceptable or usable, especially having no legal force. So the effect of the registrar's letter is that the registration certificates can no longer be used to justify possession of the designated firearm, except for the very limited purpose allowed by the amnesty regulation, not a purpose for which anyone would apply for a registration certificate. And in fact, you don't necessarily need a registration certificate under that. So there is no meaningful difference between a certificate that is revoked by a lawful authority and one that is nullified or made invalid by a lawful authority. Both mean it can no longer legally be used for the purpose of its issuance. As noted above, the Firearms Act prescribes procedures and forms to be used when the registrar revokes a registration certificate. Some of Canada's arguments suggest that there cannot be a revocation within the meaning of Section 74 of the Firearms Act, allowing referral to a provincial court unless those procedures are followed. That fine distinction might be relevant for some purposes, but it is at least reasonable to hold that the registrar cannot avoid a referral by using different words or procedures when the substantive effect is the same. And there is binding case law in Alberta on provincial courts to this effect. And quite frankly, this is fundamental to law. You can't just say, hey, I'm doing a different thing because I decided to call it a different thing. It has to meaningfully be different. You can't just invent distinctions to avoid legal responsibilities. The courts usually take a very dim view of that, but not so much when you're a government, apparently. I conclude that it was reasonable for Fradsham to hold that in substance the registration certificates were revoked. That means the registrar's letter should be read as advising the respondents that their registration certificates issued to them were revoked. So that is a big deal. Like, this is a revocation letter. And now the next question is, who revoked it? Because you only have an appeal on a revocation where that revocation comes from the registrar of firearms. And so if it came from somewhere else, then that would potentially be a reason to not have jurisdiction. Okay, sources of revocation. Let's continue on. Having found that it was reasonable for Fradsham to hold that the registration certificates were revoked, regardless of the words used, the question arises whether that occurred by operation of the classification regulation or by act or decision of the registrar, which act or decision could be pursuant to the authority to revoke a registration certificate for any good and sufficient reason under Section 71 sub 1 sub a of the Firearms Act. If the revocation was by the registrar, then the certificate holders may refer the matter to a provincial court judge. So it's basically who made this decision. Was it the registrar who made the decision, or was it Parliament? Because Canada's arguing that, Parliament automatically revoked all of these registration certificates, although they use a different word, but the court has already held that it's the same thing. So they basically say that their argument is that once they put the order in council in, it canceled all of these registration certificates that the registrar thinks it applies to. Whether or not they're right, that is a problem. That's my issue with the whole process here. But yes, so this is the question that the court is now going to proceed to answer. So, operation of law. Canada argues that the registrar did not revoke the respondents' registration certificates. Rather, Canada submits that the registration certificates became nullified or invalid as a result of the classification regulation by operation of law. Once the firearm certificates became invalid by ordinary operation of law, argues Canada in its brief, there was nothing left for the registrar to revoke. So first, where would you find that? And second, what if they're wrong? But anyway, that's me interjecting here. So the letters were informational only. Canada argues that by the mere act of reclassifying over 1,500 firearms to the class of prohibited, the certificates held by their owners were revoked, or again, nullified or made invalid. The classification regulation does not state that the existing registration certificates issued for firearms that were restricted but now classified as prohibited are revoked, or to use Canada's terminology, nullified or made invalid. Canada submits, however, that the Firearms Act requires revocation in those circumstances because Section 13 states that a person is not eligible to hold a registration certificate for a firearm unless the person holds a license authorizing the person to possess that kind of firearm. Canada argues that this section essentially creates a conditioned precedent for the continued holding of a registration certificate. Now I'm going to stop here and I say I've mentioned the immigration issue before. There's plenty of things in sort of immigration law that talk about when you're, eligible to remain within Canada and so forth. And when they decide that you are not eligible, they have to go through a process. This notion that suddenly because they think you're not eligible to hold whatever document or enjoy whatever privilege, that it happens automatically and not through, an administrative decision that you're not eligible, would have huge consequences, far-reaching consequences. And I don't think that that's really been considered. So Section 12 limits who may hold a license authorizing possession of prohibited firearms. Canada argues that if a person holds a license to possess a restricted firearm and holds a registration certificate for a restricted firearm that is then reclassified as prohibited, that individual is no longer eligible under Section 13 to hold that registration certificate in absence of a license that extends to prohibited firearms. Canada submits that the change in classification of the firearm necessarily results in the invalidity or nullification of the existing registration certificate when the legislative framework is viewed as a whole. So what happens, though, if they're wrong about that? Just because there isn't an objective truth that we have access to just because of this letter. What happens if they get this wrong? There's got to be a way to challenge that. So the respondent Durr challenges this interpretation of Section 13. He argues that Section 13 addresses the issuance of registration certificates, not their revocation, and relies in part on the French language text, which refers to when a registration certificate peut être délivré. He also points to Section 69, which uses the same phrase as is found in Section 13, namely, not eligible to hold a registration certificate. Section 69 states that the registrar may refuse to issue a registration certificate where the applicant is not eligible to hold a registration certificate. Section 13 spells out when an applicant is not eligible to hold a registration certificate. So this is a great argument and one I didn't catch on to. So yeah, this fantastic. And especially the French language, I ought to have looked at that in my own case, but I'm glad that the court is looking at it here. Read together, the combined effect of these provisions supports the argument that Section 13 is more about the issuance of registration certificates and not about the circumstances that could lead to revocation of those certificates if an individual does not hold the proper license. I am persuaded by Mr. Durr's argument that Section 13 addresses the issuance of certificates, particularly since there are other provisions that expressly address revocation. In particular, Section 71 deals with the registrar's authority to revoke a registration certificate for any good and sufficient reason, which is a really broad category and to my mind includes, hey, you're not allowed to have this anymore. That would be a good and sufficient reason, but then they have to do it through the proper channels. Furthermore, there are provisions in the Criminal Code and Firearms Act that expressly require revocation of a registration certificate in specified circumstances. For example, and as noted above, when a weapons prohibition order is made, so if you're banned from having guns, Section 116 sub 1 of the Criminal Code provides that every license and registration certificate is revoked or amended, as the case may be, to the extent of the prohibitions in the order. So that happens automatically in that particular case of you are issued a firearm prohibition because you have done something that requires that. So Sherby in Canada held that when a firearms official sent a letter indicating that the applicant's license was revoked or amended by virtue of a prohibition order, the letter was informational only and not reviewable under Section 74. And that, I think, is a very different scenario, and I would agree that Sherby is correct about that, but it's a very different kind of scenario because there's an express and explicit provision in that case. According to McEwen, there was no decision to review because Section 16 operates in the circumstance to effect a revocation. So that's automatically. In Drader is another example where there was no decision to be reviewed under Section 74 of the Firearms Act. The applicant held a license to possess prohibited firearms. By entering into a peace bond, which prohibited him from being in possession of firearms, his license and registration certificate were automatically revoked under Section 116 of the Criminal Code. Because of the effect of the statutory provisions, the appellant's loss of the right to possess the designated firearm was automatic, and accordingly there was no decision by the registrar to review, notwithstanding the issuance of the letter forwarded to the appellant, which was a nullity as there were no provisions on which to appeal. The loss of a right to possess a prohibited weapon occurred through operation of law. And again, that was through a peace bond, a court order. In Whitmore, this involved a Section 127 sub 2 of the Firearms Act, a transitional provision. So transitional is because the Firearms Act was new at that point, and so there were provisions to basically help bridge the gap between the old system and the new system. So that's what a transitional provision means. That provided for an express expiry date for registration certificates carried over from a previous regulatory regime. The transitional provision stated that the certificates would expire on December 31st, 2002. The Chief Firearms Officer refused to issue a license to an applicant with an expired registration certificate because of a requirement to have continuously held a registration certificate. McDonald said Section 74 sub 1, allowing a referral when a Chief Firearms Officer refused to issue a license, did not apply because Parliament had enacted that all registration certificates would expire on a fixed date, thus there was no discretion and no judgment involved. Paragraph 36. A further example where revocation of a registration certificate is explicit and occurs with no discretion by the registrar appears in the Firearms Registration Certificates Regulations. Section 4.1 requires the certificates to include conditions requiring their holders to advise the registrar of, among other things, any modification that results in a change of class or a change to an altered firearm. If such a condition is contravened, Section 10 states that the registrar shall revoke a registration certificate. So again, another explicit and express provision. In addition, registration certificates expire pursuant to Section 66 of the Firearms Act where the holder ceases to own the firearm or the firearm ceases to be a firearm. So that's another provision for for expiry. The form of registration certificate in the record confirms this by stating that it is valid until the firearm is transferred or disposed of, or the certificate is revoked. Thus, the statutes and regulations governing possession of firearms expressly address cases where a registration certificate or license will be revoked or will expire without a decision of the registrar. A letter from the registrar in such a case, as observed in Sherby, is informational only, but that's a different case than what we're talking about here. This is the distinction that the court is drawing. In those cases where there's an express revocation, that happens automatically. But are we in that case? We're not. Whitmore, Sherby, and Drader serve as examples in the firearms context of what may be required to apply the operation of law doctrine. There are examples in other contexts as well. Zukowski in British Columbia involved a challenge to a provincial legislative provision providing for an automatic 6 months driver's license suspension upon conviction of a designated criminal offense. It was held that the Judicial Review Procedure Act did not apply because the automatic license suspension was not an exercise of statutory power, but rather a suspension that occurred by operation of law. What these cases have in common is an express statutory provision setting out the inevitable outcome that arises in a specified circumstance. This clear inevitability is what is meant when one says the outcome is dictated by operation of law. It requires that the law is clear and its operation on the individual impacted equally so. There is no room for the exercise of discretion or argument against the stipulated consequences. They are automatic, clear for all to see, and require no interpretation. The same cannot be said of the classification regulation and its impacts on the respondent's registration certificates. This is fantastic language because of that issue. There is no room for the exercise of discretion or argument against the stipulated consequence. Here there is, because they could get it wrong. They could say, we think that this is an AR-15, but maybe it's not. Maybe it's a truck, or whatever. They haven't even said why they think that these things are covered. Do they think it's an AR-15 or do they think it's a rocket launcher? What's going on here? So, despite Canada's arguments to the contrary, neither the classification regulation nor the statutes and regulations governing firearms expressly required that the respondent's registration certificates were revoked without decision of the registrar. In the absence of such an express provision, Canada argues that the certificates must have been revoked by operation of law, yet Canada does not point to a specific law and its inevitable operation that would lead to this result. And in fact, they cannot point to it because it doesn't exist. Sorry, that last bit is me, but yeah. Instead, as mentioned above, Canada argues that the Firearms Act prohibits individuals from possessing a license to hold prohibited firearms, subject to certain exceptions, and that an individual cannot possess a registration certificate for a prohibited firearm unless that individual is licensed to possess prohibited firearms, sections 12(1) and 13. Canada submits that the respondent's registration certificates related to restricted firearms, but that the amendments to the classification regulation resulted in the reclassification of those firearms from restricted to prohibited. Canada further states that the respondents are not eligible to hold a prohibited firearm registration certificate for these newly prohibited firearms in the absence of such a license for such possession. Canada concludes from these provisions that the respondents' registration certificates for restricted firearms became invalid as soon as the Order in Council reclassified the corresponding firearms as prohibited. This interpretive exercise does not have the clear, automatic, and non-discretionary certainty required for an outcome governed by operation of law. I love this in terms of the language here. It is, this is beautiful and brilliant legal writing right here. Now, it's going to get better because the justice is clearly calling BS on some of the arguments Canada's made here. So let's keep going. Furthermore, the rule of law, principles of statutory construction, and principle of parliamentary sovereignty do not permit the interpretation Canada proposes. The rule of law has been foundational to the Anglo-Canadian constitutional and legal system for centuries, articulated in authoritative treatises, and they go through and list a number of books, recognized explicitly and implicitly in the preambles to the Constitution Act 1982 and Constitution Act 1867, and applied by the Supreme Court of Canada in many contexts. The principles are ably summarized in a book called The Law of the Canadian Constitution, 2nd edition. So this is a big deal, is what the court is saying. So recent jurisprudence establishes three main elements comprising the rule of law. First, it means that the law is supreme over officials of the government as well as over private individuals, and thereby preclusive of the influence of arbitrary power. Now, this is a really big deal because when you think about it, the law controls individuals in a lot of ways, but it also protects and shields us from both the actions of, bad individuals, people who might be wanting to be lawbreakers in some fashion, but also from the government itself. There are many legal provisions that exist to provide us with protection from the government. The Charter of Rights is one such legal document that exists to shield us from the government. But when we look at sections 74 to 81 of the Firearms Act, they have the same purpose. They are there to provide a review process in case the government gets it wrong, and gets it wrong for all sorts of reasons. They might make a mistake, but they might, for instance, be biased against you for some reason. And so there is a provision there to allow you to defend yourself. And so one of the critical elements of the rule of law is that it has to bind the government as well as the individual. This is fundamental and foundational to the rule of law. And so I think this is a big deal here. When talking about whether the standard should be correctness or reasonableness, the fact that the very rule of law is implicated by this issue is, to my mind, something that is a consideration. But let's keep going. Second, it requires the creation and maintenance of an actual order of positive laws which preserves and embodies the more general principle of normative order. So that means that you have to have a legal structure and framework. Decisions can't be made simply because, some guy who sits in a really big fancy chair feels that that is the way to go. They have to be decided on a legal basis. So judges decide based on laws and past precedents and so forth. But, you can't, your local mayor has to actually pass a law if they want to change the rules. They can't, they're not just sort of warlords or whatever else. Third, it requires that the exercise of all public power must find its ultimate source in a legal rule. So again, you can't just have some authoritarian figure who says, we're doing this because I say so. It's got to actually, you got to have laws. And yeah. So this is a big deal when we're talking about the rule of law is implicated here. The rule of law, and continuing back with the case here, the rule of law conveys a sense of orderliness and executive accountability to legal authority and vouchsafes a stable, predictable, and ordered society in which citizens and residents may conduct their affairs. It requires that governmental powers or any authority delegated by Parliament must be exercised pursuant to valid laws, either directly or indirectly permitted by an act of Parliament or a legislature. In the words of Chief Justice Laskin, there is no principle in this country, as there is not in Great Britain, that the Crown may legislate by proclamation or order in council to bind citizens where it so acts without the support of a statute of the legislature. Now, lots of people are going to be seeing this going, wait a minute, they can't use an order in council. In terms of firearms bans, there is actually a statute that allows for that order in council to be issued. So that's the distinction there. But they do need that statute to support it. So they couldn't, for instance, issue an order in council that purports to revoke all registration certificates, because unless there's a statute that allows that, they can't do that. Nor could they, for instance, issue an order in council requiring that a particular individual, Ian Runkle as an example, be incarcerated. They'd have to have some legal reason for that. So that's the power that they're really trying to curtail with the whole rule of law thing, is you can't just, they can't just rule by fiat. This constitutional requirement that governmental power must be exercised only as permitted by an act of Parliament presents a challenge to Canada's argument that the classification regulation resulted in the inevitable revocation, nullification, or invalidation of the respondents' registration certificates. Under Section 117B of the Firearms Act, Parliament expressly granted the Governor and Council the power to regulate the revocation of registration certificates, but Parliament also stipulated in Section 118 that in so doing, the proposed regulation must be laid before each House of Parliament. Thus, for example, both the Firearm Registration Certificates Regulation and the Firearms Licenses Regulations were laid before each House of Parliament before becoming effective. See the preamble to each regulation. Given the principle of the rule of law that the exercise of legal power must find its source in a legal rule, it is doubtful that Parliament could have intended these express provisions requiring parliamentary oversight of regulations relating to the revocation of registration certificates to be evaded by the indirect, non-express mechanism for which Canada argues. Oh, I love this. And if I didn't have work to do later tonight, I would be enjoying this with a scotch. But I do, so I'm not. There are also principles of statutory interpretation that contradict the by operation of law interpretation proposed by Canada. It is presumed that the legislature does not intend to confer a power on subordinate authorities to make regulations or orders that interfere with vested rights. So, again, real nice there. The statute should not be given a construction that impairs existing rights, including property rights, unless its language clearly indicates such an intention. As noted above, there is no such clear indication in the classification regulation, nor in the Firearms Act, that requires the interpretation that the registration certificates have been revoked, nullified, or invalidated by operation of law. Lastly, the principle of parliamentary sovereignty also supports this conclusion. Only the legislature has the authority to enact, amend, and repeal any laws it sees fit, and having done so, no person or body is recognized as having a right to override or set aside the legislation of Parliament. Given the express statutory requirement in Section 118 that regulations revoking registration certificates must be placed before both houses of Parliament, there is no reason to assume the Governor and Council had the discretionary power to revoke registration certificates through the classification regulation. It was open to the Governor and Council to specify this outcome, but to do so it had to follow the process set out by Parliament in the Firearms Act, and not simply, and this is again me chipping in here, and not simply be that they have invented some new classification of nullification or administrative expiry. Continuing on, as I said, this is a great decision. If there is a conflict between the classification regulation and the registration certificates, as Canada argues, it does not mean the classification regulation is functionally paramount. Parliament expressly said how revocations are to be regulated. Rather than Canada's position, a restrained approach to determining the effect of the classification regulation on the registration certificates is called for, an approach consistent with Parliament's language in Section 118 of the Firearms Act, the strict construction of legislation that is penal in nature, so criminal, you can go to jail, or impairs existing rights, and basic principles of the just treatment of law-abiding citizens who have relied on government-issued documents to possess certain items. So I'm going to say there's plenty of commenters online who have said, oh, well, this is just about guns, I don't care, or whatever other sort of things. This is what this is about, is the just treatment of law-abiding citizens. It extends this principle, the issues at stake, extend beyond guns. These are an issue of how the government relates to its citizens, whether they are required to follow the rules that are set out to protect the rights of the citizenry. And this is such a critical kind of issue. And if these arguments that Canada is making are accepted outside of the firearm regime, it would overturn many elements that are fundamental to the rule of law. So carrying on. As an aside on interpretation, it may be, as suggested in Carina in Canada, that the amnesty regulation could be read as assuming that registration certificates would be revoked when the classification regulation came into effect. However, such an assumption would be equally consistent with anticipating revocations by the registrar as decisions under Section 71 sub A of the Firearms Act, which is how they should have done it in my view. Again, that's my interjection there. More basically, whatever support the amnesty regulation might give to interpreting the policy objectives of the classification regulation does not assist Canada in establishing how the Governor and Council could implement that policy without following the parliamentary procedures set out in Section 118. So even if that's what they meant to do, they didn't do it. In the absence of proper process and an express statement that previously issued registration certificates were revoked, and in the absence of any other provision in the Criminal Code or the Firearms Act mandating revocation in these circumstances, the revocation, nullification, or invalidation of the registration certificates did not occur by operation of law. As indicated above, in substance, the registrar's letter revoked the registration certificates. In addition to the fact that nullification, making invalid, and revoking amount to the same things in these circumstances, I find that the registrar's letter represented a decision on what to do with the affected registration certificates. The parameters of the registrar's discretionary authority under the Firearms Act is such that the decision was a revocation and subject to the reference provisions in Section 74. I like this a lot. It is really clear writing. It really cuts through the bullshit. And that's what I like to see in a decision. I mean, it helps that I agree with the decision, but I think that they're really cutting through to the fundamental principles here. So effect. During the hearing of this application, occasionally there arose the question of what the effect would be of a possible decision in provincial court that despite reclassification of firearms for criminal code purposes, the respondents' registration certificates remain valid. The respondents took different positions on this hypothetical question. Some argued that their certificates would then allow them full possession rights until expiry or lawful revocation by the registrar. I'm not sure that that's actually an accurate position. I'll explain why in a moment. Others referred to the possibility of grandfathering provisions or the possibility that the regulatory regime allows for the possibility of replacement certificates for prohibited firearms should the governor in council or parliament choose to implement such a regime. No doubt there are other possibilities. And I think the court is correct in this next statement, but I'm going to still opine as to that hypothetical question. So the next statement, this is what the court says. It is not for me on the certiorari application to determine how a Section 74 referral might proceed or what decisions and remedies could result therefrom. Where the standard of review is reasonableness, courts must exercise judicial restraint, respect the distinct role of tribunals under review, and intervene only where it is truly necessary to do so in order to safeguard the legality, rationality, and fairness of the administrative process. So the court is punting here. They're saying, this is not our decision, and so I'm not going to base my decision on this hypothetical question that you guys are asking. That's for the provincial court. And I'm sending you down there. You're going to have that fight on that issue. So go fight that issue. But we're not doing it here today. And that, I think, is exactly the right course for the court in this particular matter. However, in terms of that hypothetical question, because lots of people are wondering this, I mean, you need a valid license and registration for the classification. So if you don't have a license that authorizes you to possess prohibited firearms, you probably don't have full possession rights. It probably doesn't affect ultimately what you can do with the firearms, but it does require them to follow the process. It says you guys have to, you have to do this correctly. And because if you get it wrong, because that is a real possibility here, is if they get it wrong, people have to have that process open to them to challenge it. Okay, continuing on, we're almost done here. We're getting to the last bit here, connecting the dots. Some respondents, but again, not all, argued that the registrar must have made a decision with respect to each notification letter because it is not possible to match the lists in the classification regulation to the description of each firearm in the registration certificates. Canada responds that the procedure for determining which firearms are captured by the classification regulation would be a clerical function involving the detailed records kept by the Canadian Firearms Registry. The record before me does not permit a determination on this point, that is, whether the registrar was required to make a decision with respect to each firearm in each registration certificate. Given my other findings, it is not necessary to address this point further. So they don't have the evidence on this one. I think fundamentally it's impossible to make this determination without it. And when they say it's a clerical function, I mean, it's a clerical function that is still a decision of the registrar. You still have to make the call. Even if you're just talking about comparing two documents to determine if they are the same thing, this is a decision that potentially involves some, potential for error. Somebody could make that mistake. So other cases, there are many other cases from provincial courts in Alberta and across the country that differ from my conclusion. They find that there is no jurisdiction to hear a Section 74 reference under the Firearms Act because the classification regulation rendered the registration certificates null, void, or invalid by operation of law. A good example is Carina in Canada, which discusses many of the other cases in arriving at such a conclusion and has in turn been relied upon in subsequent decisions. In Carina, Legrander was of the view that the lack of express provision in the regulations that the registration certificates were invalidated, revoked, or nullified was no bar to finding that they were. In fact, he criticized Fradshem's decisions because they failed to apply the doctrine of operation of law. Legrander found that the regime in place before the classification regulation was impliedly repealed and replaced. The classification regulation and the amnesty regulation expressed an intention to replace the old regime with regard to changing the subject restricted weapons into prohibited weapons, with the consequential nullification of the registration certificates for the firearm as a restricted firearm. And it was clearly consistent with the change of legislative policy that the old registration certificates were impliedly nullified or revoked or invalidated by operation of law. For the reasons already given, I find that such an expansive application of the operation of law doctrine cannot be supported. So this is an explicit overturning of Carina. Properly speaking, operation of law should be limited to cases where the result is clear and automatic. No one should have to guess or rely upon an informational letter when Parliament or the Governor and Council can easily state what is intended. More importantly, Carina does not address the fact that the Governor and Council had no authority to effect what, on Canada's argument, was an intentional, if not express, revocation or nullification or invalidation of registration certificates without laying the regulations before Parliament under Section 118 of the Firearms Act. If the Governor and Council is presumed to know that immediately upon the regulation coming into effect that the registration certificates are no longer legally valid, then it has attempted to do indirectly that which Parliament expressly said it could not do. Carina relies heavily on Barrett in Canada. It bears consideration because while not binding in Alberta, it has been relied upon as persuasive authority. Barrett is a case with very complicated facts based on a series of legislative changes to the regulation of firearms, which were implemented and made effective over many years. The basic facts were that as part of enacting the Firearms Act, former firearms acquisition certificates were deemed to be licenses. Ms. Barrett allowed her firearms acquisition certificate to expire in February 2000, its originally expiry date, because she did not intend to purchase more firearms. Unfortunately, this meant her deemed license also expired on that date. So that was a deemed possession and acquisition license. She never actually got a possession and acquisition license, but because she had that FAC, it was deemed that she had one. So it's complicated. And if you didn't live through that, then you may not follow all of this, but the transitional provisions were a big deal back at that time. The transitional provisions also stipulated that previously issued registration certificates would expire on December 31st, 2002. Furthermore, to retain prohibited handguns, an owner had to have been continuously the holder of a registration certificate from December 1, 1998 onwards. Ms. Barrett applied to renew her registration certificates. The registrar refused her application because she no longer held a valid license. McEwen said that the registrar was required to refuse Ms. Barrett's application for registration certificates because of the state of the law. And you can see where this is going. There's an express expiry that's written into that. Section 13 provides that a person is not eligible to hold a registration certificate for the firearm unless the person holds a license authorizing the person to possess that kind of firearm. But in my view, he went further than necessary by also holding that Ms. Barrett was not continuously the holder of a registration certificate, a requirement of the transitional legislation, on the ground that without a valid license, she could not continue to hold a registration certificate. In effect, he found that Ms. Barrett had become ineligible to hold a registration certificate because of the expiry of her license. That finding, in the nature of obiter dictum, is contrary to my conclusion that Section 13 deals with the issuance of registration certificates, not their revocation or invalidation. Thus, I respectfully disagree to the extent that Barrett can be said to support Canada on this point. Now, what does obiter dictum mean? It means kind of by the way. It's not part of the actual critical elements of the decision, and therefore it's not binding. It's other language that courts may or may not later find persuasive or helpful, but it's not part of the binding law. So when there's an obiter dictum statement, even by a higher court, a lower court is not necessarily bound to follow it. It's only sort of valid to the extent that the reasoning is good. So that's why it's noted as being obiter. More importantly, however, as in Carina, Barrett does not address the limit on regulatory power imposed by Section 118 of the Firearms Act. That is a point of fundamental importance in this case, on which Barrett gives Canada no assistance. So there's a limit on that power. You can't do anything about it. Conclusion. For the reasons given, I find that the learned provincial court judge reached a reasonable decision in concluding that he had jurisdiction to hear the respondent's references under Section 74 of the Firearms Act, although my reasons go beyond his. And in fact, they not only go beyond, but they explicitly overturn a previous case that the Crown was relying on quite heavily. He thoroughly considered all of the relevant statutory and regulatory provisions in concluding that the registration certificates were, in substance, revoked, and that this resulted from an act or decision of the registrar. Accordingly, Section 74 sub 1 gives each of the respondents the right to refer the matter to a provincial court judge. As emphasized above, the way this matter comes before me is, in provincial court, Canada applied to strike each of the referral applications for want of jurisdiction. The applications to strike were dismissed by the provincial court judge, and that Canada applied in Queen's Bench for certiorari to quash the dismissal of the applications to strike. I dismiss Canada's application for certiorari, the provincial court's dismissal of its application to strike the Section 74 references. Those references are therefore remitted to provincial court to be heard in accordance with the Firearms Act. So a lot of you are probably sitting here thinking, all right, that's a lot of really good explanation, Runkle, but what does this mean at the end? What is the impact? And the first thing is that this case explicitly strikes down a previous decision that was a problem for a lot of gun owners. And it shows why the reasoning in that case was flawed. So that case is no longer good law, which is also going to create a problem for other decisions that were relying on that case heavily. As I said, I think that this reasoning is really good. I think it's really... and I said that about Fradsham. I said I think that this is a solidly reasoned decision and is likely to be upheld. And hey, I feel like I can say, you know, that's a point in my corner here. So this is a really big deal. As you probably know if you watch this channel, I've got my own Section 74 application going on. It was struck for lack of jurisdiction, so the opposite of what happened in Fradsham, and I'm going to be challenging that decision. And do you think I'm going to be citing this case? You better believe it. And do you think I'm going to be sending Mr. Dunn a bottle of scotch? You better believe it. I mean, I could not have gotten a better birthday gift here. My wife is going to be annoyed because now she's got to compete with this. Although it's not a competition, my wife always wins. But it's a, you know, this is a big deal. And as I've noted before, I think this case ultimately ends up in front of the Supreme Court. There's too many issues at play. And the larger issues here are what it takes for the government to sort of wriggle out of these judicial review procedures. And I think that's a really big issue with really far-reaching implications. So I really like to see this decision. And I mean, I don't always like decisions that are in my favor. I mean, I will admit that there's always a bias to say, hey, this case that agrees with me is got to be a good case. But one of the worst things that can happen is if you get a case that's really in your favor and it's terrible and you think it's not going to be upheld when you think that this case is going to go to like larger later appeals courts. So I really like that this is a very careful decision. It spells out what the issues are and where previous courts got it wrong. I think that this is basically a scalpel cutting through some of the previous sort of issues, previous arguments that I think are flawed. And so I'm quite happy with it. Anyway, thank you for watching. I hope this has answered some of your questions. If you have more questions, leave them in the comments below. I'll try to check that out. Thank you for watching. As I said, please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, Jonathan Wheeler, Canada's National Firearms Association, Mike, Kyle Martin, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Demour. And at the $20 level, Peter Hilger, Matt Ward, Mark Whittington, Jane Babin Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Delsu. Thank you as well to all of the $10 supporters who are going to be in the crawl immediately following. The fight still keeps going on, and, you know, there's always going to be a tension between the government and the citizenry in the sense that, you know, people are bound by laws and they don't always want to be, or they don't always agree with the government's interpretation, or they don't always think that what the government is doing is fair. And there's many examples of governments doing things that are unfair in some fashion. So the existence and the vitality of these kinds of challenges to government authority is a really important thing in society. No matter what your pet issues are, you might be somebody out there who hates guns, who thinks I am, thinks that I'm growing my hair out to cover the horns. You might really, really dislike me, and you might really, really dislike guns. But I guarantee you, whatever your personal issues are in terms of what you care about, what you think matters, these principles that are at stake here touch on whatever it is you care about. Anyway, that's the video. Thank you for watching, and hope to see you next time. And I hope I've armed you with knowledge.